You know, that whole thing about, oh, you can't raise someone else's Fifth or Sixth Amendment rights in your, yeah, the prosecution had to concede that we were right. They conceded it in court. So I guess maybe someone in their weird rage forgot that the confrontation clause exists. That little thing called the Constitution that you have to, like, kind of use as a rule book that exists. And like people are like, just forgot that the confrontation clause exists. And you can't just like do an end run around people's Sixth Amendment rights or their Fifth Amendment rights and then try and get inadmissible statements admitted. Like, they don't just let you do that because the person who you're doing that to also has rights, even if they're not directly implicated. And one of those rights is the right to confront any witness against you. But like, if you can't call that witness because they have a Fifth Amendment right that you can't pierce, the state doesn't just get to use that. And you know how you know this is true? Like, this is the funny part. You know this is true is because they don't just do it all the time, because they just do it all the time. If it worked the way that certain reviewers thought it would work, they would just always do it, because you could always get someone else to make the statements that you need without Miranda and then just trample on the rights of everybody else. They just do it all the time. Sometimes, about some of my friends, I'm sitting here and I'm going, I know they keep saying that I'm a non-practicing lawyer, proudly so. I know they keep saying it, but I'm just sitting here going, but their analysis is bad. Sometimes I just wonder, like, how much non-practicing lawyer derangement syndrome some of these people have. And I'm like, guys, like, please stop doing bad analysis because you're mad about something, whatever it is. I don't care, but like, stop throwing your own integrity down the toilet. That's weird. It's just me. You don't need to help people hate me. They do it already. They do it for free. They do it for free. They don't need you. Like, just calm down. Out there screaming and yelling, like, I can't believe he's doing this. Like, and yet we go in and the prosecutor's like, yeah, that whole thing was really bad, where he kind of just like steamrolled her Miranda rights, or the reading of Miranda and her assertion of Fifth and Sixth Amendment rights. That was probably not good. So we're just going to let that issue go. So I'm just sitting here going, why do they think this is a motion to suppress? And it's great because they're going through all these analyses, right? And they're like, no. Look, the video's the exact same. Of course it's the exact same. Look, it's there's no edits here. There's nothing here. There's nothing here. It's like, but what you're doing is you're arguing about the sufficiency of the evidence for a trier of fact. But we're not at trial, guys. We're not even close to trial. We're not asking a judge to rule on the sufficiency of the evidence, because what you've done is presented an argument as to why this evidence would be admissible, but admissibility isn't the issue. And if you're stuck on the admissibility of the video, I'm just going to encourage you to go back and read the document again, because it lays out that, again, this is a Frank's challenge. The Frank's challenge is about the sufficiency of the warrant request. What if I told you that there's a non-practicing lawyer out there who is representing a client in a felony possession case in Candy, Ohio County, in front of Judge Wenzel, and won that case on a Frank's challenge to a warrant, where the prosecution, or I guess actually just the affiant, the officer who requested the search warrant, lied about having a confidential informant. They actually called them a concerned citizen when they were a confidential informant. What if I told you there was a non-practicing lawyer out there who won a case in front of this judge on this issue, which is embarrassing to be worse at this than me? That's the biggest own I can imagine. How can you be worse at lawyering than I am? The video. You want the video? Like, does the state need the video? It's still there. It's still on Rumble. It's still on YouTube. It was never taken down. Go visit the URL. It'll tell you it's private. It is. But they can easily get that video from YouTube, right? Yes, they can. Why didn't he? Well, they could easily get that from Rumble, right? Well, yeah, he can. Why didn't he? Isn't that strange to you? Doesn't that bother you? Why he would say he got it from YouTube and Rumble? Why he would say he reviewed my video, but then not actually do that? When he could do it easily. Or better yet, what he could have done was just say that he didn't. He could have just said that he didn't. I watched it from this other place. I found it reliable. Okay. But why didn't you? Why didn't he do that? Maybe he had doubts about its reliability. Maybe it's because cops lie sometimes. Maybe it's because cops lie a lot of the times. But the embarrassing thing is not even the cop lying. Oh, and by the way, I can prove it because we have to be able to raise this challenge. That's the thing. You don't raise a Frank's challenge willy-nilly. You don't go, I'm going to take a shot in the dark. That's why what you actually are doing is asking for the judge to grant a Frank's hearing. And at the Frank's hearing, there will be an evidentiary argument. And we'll find out. We'll find out if the cop lied or not. He did. He did. It's easy to prove. It's easy to show. You have to use the information that they provide in the warrant and through discovery. You have to know. Numero uno Josh Denny fans is it's the same video, retard. There's nothing different on your video. You're arguing the wrong thing. That's the best part. You're arguing the wrong thing. And that you can't figure that out is the fault of the practicing lawyers who can't seem to analyze a Frank's challenge. I'm sure I'm just like, of course, because what I did was I just hired an attorney who he would just let me draft all the motions and everything, and he just sign them, right? Like I've seen that as if, first of all, as if you'd hire someone to do that anyway. But second of all, as if he would forego his ethical obligations and do that is ludicrous. But people just can't figure out why the practicing attorneys who are all sitting on YouTube more than I am, why they're getting this shit wrong. What's that temptation, right? When you forgo your legal analysis, you throw away your credibility on the altar of super chat money. Hope it works out for you. I hope you all make $1 million.